I'm Mark Granger with Pacific West Mortgage Fund. Our podcast today is brought to you by the Granger Company, a full-service commercial real estate business operating in the Southern California area, specializing in property management, leasing, and sales of commercial property. Today we have a very special guest with us, Marina Feynman, and our topic today is going to be bankruptcy, which is unfortunately a topic that we're seeing more and more of in sort of problematic times here in the economy. We're starting to see more and more of that, certainly with Pacific West Mortgage Fund. So Marina, I know that this is a huge topic. We could probably talk about it all day long. So let's just start out with, in the essence of time here, just tell us, what is bankruptcy? I mean, just in general, is it a state court system? Is it a federal court system? What's the purpose of bankruptcy? Just generally kind of flesh it out a little bit for us.
Okay, well, it is a federal court system. There are federal bankruptcy courts and federal bankruptcy court judges that get appointed for 14 years at a time, unlike a normal federal judgeship, which is for life. And the general premise of bankruptcy is to give a debtor a fresh start. So to do that, the automatic stay gets imposed, and the stay is on all proceedings. Okay,
we're going to cover the stay and so on, but
yeah.
So just to recap very quickly, federal court, judges are appointed for 14 years. Is there a bankruptcy court in LA County and Orange County, or are they?
Yes, there are different. We're in the Central District. There's one in Santa Ana. There is a San Diego one. There's one in the San Fernando Valley, Los Angeles County, Santa Barbara. So
okay, all right, great. So I have Patrick, my son, who does primarily property management for the Granger Company. Bill Fox is a correspondent lender with Breakwall Financial. I've opened the floor for questions for Marina. So, gentlemen.
Shall I start, Bill, or would you like to start?
Well, go ahead, Patrick.
The first question I have here is, well, as I said, really ideal mostly with tenants. And I know I'm not sure if we necessarily want to start down that hole, but I mean, what can you expect as a landlord if your tenant comes to you and says, you know, maybe you had some inclinations, but your tenant comes to you and says, we're filing for bankruptcy? I mean, what can you expect to come from that?
Well, are they current on their rent payments?
Let's say they're behind a couple months on their rent payments, and you've given them a break up to this point, and then they come to you and say, you know, this isn't working out. We need to file bankruptcy.
Yeah. Well, so what happens is once they file, and presumably you may be making some collection efforts before the filing. You may be calling them, asking them to pay. You have to stop all of that. The automatic stay stays every collection effort by any creditor. It stays all litigation where the debtor is a defendant. So it just pauses everything to let the debtor figure some things out. In terms of a tenant, once they file, they still have to continue on to pay current rent. But in terms of overdue rent, that is going to get paid out through the bankruptcy case.
So they would still be, I suppose, required to pay current rent? I mean, theoretically, if you're going through I would imagine, I guess is the way to say it, if you're going through a bankruptcy process, you probably don't have the money to be paying your current rent.
Well, then you would have grounds as a landlord to request from the court a relief from stay, and that is another term of art I'm going to be using a lot, because there's the stay and then there's the relief from the stay, and that is where all the creditors come in, where you can't do anything against the tenant without first getting court approval. So what you would do is go to court, say they're not paying, I would like relief from stay to proceed in state court with an unlawful detainer action.
Right.
And so once the bankruptcy court allows that, then you can go ahead and proceed.
I see. So the relief from stay actually just, it's sort of the exception to a bankruptcy, to what you would normally be dealing with in a bankruptcy.
Well, it's not an exception, but it's part of the process.
Right.
So if there is cause to lift the stay, then the bankruptcy court will do that. And also, if there's a tenant and there's a lease, then a lease is called an executory contract. It's a term of art in bankruptcy. And a bankruptcy debtor has the right to either assume the lease, And so let's say they wanted to assume and stay, then they would have to cure any defaults, and that means paying all the back rent, or they could reject.
I think that the thing that we want to zero in here is that there's two key terms you mentioned here, and I think the first is once they file the BK, whether it's a $99 one or the O'Melveny and Meyer version, everything freezes. You can't do anything. Either as a tenant or a lender, you're now basically prevented from going after these people any further than whatever you can negotiate. The goal, however, is to get what's called a relief of stay, which is what you have talked about, which is as far as you're concerned with this creditor, or excuse me, you are the creditor, you're going after the debtor. So when you get the relief of stay from the debtor, you are now able to move forward with whatever legal action you have against that person in the bankruptcy. They're no longer protected by the bankruptcy.
Right. The relief from stay is from the court, but yes.
Yeah. Okay. All right.
Well, no, not from everything, just for your specific thing.
Right.
So the stay applies with respect to every other collection action litigation. It's
so we see this a lot with Pacific West Mortgage Fund. They file foreclosure. We go through the foreclosure process. On the 21st day of the notice of sale, they file a BK, and it just stops it generally for 90 to 120 days. And during that period, what we're trying to do is get a relief of stay because we want to get that foreclosure moving again. And depending on who you're dealing with and how sophisticated they are and who the judge is and all these other variables,
exactly,
you can go but the end result is to try and get that relief of stay so that you can move forward with whatever action, either an eviction or a foreclosure in our case.
Right.
Right. So with that in mind, I know Bill had a couple of questions about the different types of...
Right. What are the differences between Chapter 7, Chapter 11, and Chapter 13 from a lender's or landlord's point of view?
From the creditor, yeah. So I'll try to keep it brief. There are a lot of things, but basically the structure is that a Chapter 7 bankruptcy case is where it's a liquidation. And that could be for an individual, and it can be for a company. And so at that point, once the debtor files for bankruptcy, and then assuming they have 14 days to file all the schedules and other things that are required, if they meet that, then the Chapter 7 trustee takes possession of all of the assets, the rights, everything gets turned over except for what are called statutory exemptions. So you get a certain amount of money to keep certain jewelry, to keep a house. A house I'll get to, but to keep a car and things like that. Everything else gets turned over. And the trustee then looks at everything, sees if there are any assets to be sold that will make money with which then the trustee will use to pay unsecured creditors. Mm-hmm. So that's the general premise for both. Chapter 13 is for individuals who don't want to give up their assets. And there's a cap on your debt of about $1.4 million. Mm-hmm. And you can also, if you have a small business, put that in with that bankruptcy, but it's not a bankruptcy. It's not a chapter available to just companies. And so in that case, you immediately file a Chapter 13 plan, and a Chapter 13 trustee is appointed. And then you have to start making payments immediately under that plan, and then the debtor goes through the process of trying to confirm that plan and paying back the debts over 5 years so that or less, so that they can do that. So it's kind of a mini reorganization for a person. A Chapter 11 is a full-blown reorganization.
It's like General Motors did.
Exactly. And that can be, if you're a high net worth individual, you would do that. Otherwise, it's mostly for corporations.
So did I understand you, it's not to interrupt you, but on the 13, the limit to a 13 is 1.4 million or less?
What your debts are, I believe it is something
like that.
If you have more than that, you're forced into an 11.
Exactly.
Okay, all right.
Exactly.
So the trustee takes over on the bankruptcy.
In a 7.
in a 7. In 11 and 13, it's a different situation then?
Right. In a 13, the trustee's appointed and they're responsible for monitoring the plan, making sure the debtor is doing what it needs to do, and then complying with the plan payments once that's confirmed.
Okay.
So can a landlord or lender challenge the bankruptcy filing if they feel there's abuse somewhere, they're hiding assets or doing something funky? How does
Yes,
that work?
absolutely. You can file a motion to dismiss
But
based
those
on
aren't
fraud.
generally granted, are they?
It depends on the circumstances and it depends on the chapter. So again, the standard for dismissal in a Chapter 11 is very different of what it might be in a 7.
So if it's dismissed in a 11, does it automatically convert to a 7 then?
No, nothing automatically converts. The judge has to decide. Sometimes you'll file a motion to dismiss or convert, or in a Chapter 11 case to appoint a Chapter 11 trustee. So if you think that the principal is committing fraud in a Chapter 11, you may say to the court, look, something's very fishy. We need someone who we can trust in the company.
Is it pretty common to see these chapters switch or be converted into other
Yes.
different forms?
Yes. Or if, 13 is filed and there's no way that debtor is going to be able to make any payments, there's no income, the court may decide to convert, depending on what the facts are.
Is that conversion, we're getting into the weeds here a little bit, but is that conversion, that's not, sometimes can be done involuntarily from the debtor's perspective? I mean,
Exactly,
the judge
that's
just
the
says,
motion
yeah.
that any creditor can bring.
Okay.
Or sometimes it's the trustee, the 13, or the Chapter 7, or the United States trustee, which I haven't mentioned, but that's sort of the governmental oversight agency that oversees every case, and that's in every chapter.
So there's a term in bankruptcy called a debtor in possession.
Yes.
So from Pacific West Mortgage Fund is a private money lender, as you know. We've done a lot of work with Gerasi. They do all our legal documents. Can you loan money to somebody that's in bankruptcy? They have a loan with, City National Bank, for example. They want to pay off that loan. The loan's matured in this example, and they come to a private money lender because they can't go to a bank. Can you make a loan to somebody in bankruptcy?
You can. What I will say is just generally for creditors to keep in mind is that everything that happens has to go through the court. So the debtor is not allowed to do anything. A debtor in possession is a term for a debtor in Chapter 11, and that means that they're in possession of their assets as opposed to a Chapter 7 where everything is turned over to the Chapter 7
So a debtor in
trustee.
possession isn't necessarily a court-appointed person. That's somebody that may be in the company or something?
No, the debtor in possession is the entity that filed. The debtor is the company or the individual. And they are in possession and continuing to run the company and do everything. They're in possession.
So that's a term that means that it's post-filing, post-petition bankruptcy, and they're continuing to operate but they just need some relief from their creditors, and so they're dealing with additional creditors or borrowing money or vendors or whatever, but they're doing it within the framework of a bankruptcy.
Exactly.
Okay. All right.
So if I understand well, Chapter 11, they establish a plan. It's usually like a 5-year wheel or something like that, right? To get out?
Chapter 11 is different. The Chapter 5 is commonly 5 years. Chapter 11, there's no particular parameter.
How many Chapter 11s actually get completed? Isn't it true that they most of them set up a plan and then they don't execute on it and then they don't really get to discharge, or is that?
No, I wouldn't say that's true of Chapter 11s.
Okay.
Yeah, that is common more, I would say, in a Chapter 13. Chapter 11, assuming that it was done properly, and sometimes it's not a reorganization. You can also have a liquidating Chapter 11 plan.
Oh, really?
Yeah.
So it's an orderly sale of the assets,
exactly,
right?
because you want to be the one. The company is usually the best suited and positioned to sell, market its own assets, and so I'm doing that right now in a real estate matter. Yeah.
I think that it's really important for our listeners to understand that bankruptcy is really, as I understand it, and I want you to make sure you're confirming this now. My experience is bankruptcy is really designed to give the debtor an orderly, either an orderly opportunity to reorganize and get the business up and running, or if they are going to liquidate assets, it's done in a fashion that all of the creditors are get the maximum that they can expect to get. They may not get 100%, but at least they're not being forced. The typical example with a real estate situation is you have secured lenders and unsecured creditors, and the secured creditors come in and take 99% of the assets, and the unsecured people get nothing because they're jamming the sale of the property through, which is the main asset in the estate.
The point is to get as much for all creditors as possible. So, for example, if you have a debt of $5 million and the property is worth $10 million and you're trying to foreclose, you're trying to take that $5 million. Well, that's not fair because they've got unsecured creditors who are owed $5 million. And so the point of this is to let the debtor in possession or the trustee sell that property, take that $5 million, and then use it for the other creditors.
Okay.
Is there sort of a hierarchy in who gets paid back?
Yes, there is a statutory priority scheme, and it just depends. There are the secured creditors, and you're secured up to the value of your collateral. For the balance, you would get an unsecured claim if you're undersecured, for example. Then there are priorities. Administrative claims are paid next, which are the debts that are incurred after the filing. So anything that the company has accumulated in debt, also all the professionals, the trustee, the court has fees, the U.S. trustee has fees in a Chapter 11 that have to be paid. Chapter 7 trustee gets fees.
So those people, the professional people you just mentioned, they're junior to the secured lenders that were filed. If you have a loan and they file BK, and then they hire a bunch of people to work on that case, you're still senior to those people?
You are in your collateral, but what happens in these big bankruptcy cases, because it's for the benefit often of the secured creditor who's, a lender who loaned money, millions of dollars, for this to be administered in the bankruptcy. And so they'll often give a carve out of their own collateral to be used to pay professional expenses. That's very common in these big Chapter 11.
So like Chapter 7 trustee, they actually get a percentage of the revenue that's brought in, right?
Yes, of the assets. Yes, they're distributed and they get certain fees. Yes.
So does that change depending on the value of the estate? How much?
Yes, it's a percentage.
Okay.
With caps and things.
Interesting. Yeah. Okay. Wow.
Which is why they're always interested in administering cases with assets, because for the ones without, they get, $60 or something per case, and they
Is that true of a
it.
13 too, where they get a percentage of?
Yes, the Chapter 13 trustee gets something like 10 or 11%. Don't quote me on that, but of what's paid out under the plan.
Got it.
Interesting. Wow. That's something I just learned. I didn't realize. I know trustees are always. That's an interesting business. We could spend hours talking about it, but it's
hierarchy is the feds always get paid 100%, right?
No, not necessarily.
Really?
There are administrative claims in the priority scheme. Then there are what are called priority claims, and that could be things like child support, things like wages earned by employees in the first 90 days.
How about IRS loans?
IRS taxes that are more current, not old ones.
Oh, really?
So there's a scheme as to what is a priority unsecured claim. So it gets paid administrative, then priority unsecured, then the general unsecured.
So the lawyers always get paid, right?
Not always, no. You have to make sure you get a carve out or, the debtor is going to have enough money. And bankruptcy professionals often aren't paid for months at a time.
Oh, really? Interesting.
Yeah.
Yeah, well, that doesn't sound like a good deal for you.
Well, I'm representing the creditors at Jurassic, so that's
Generally,
not the same, right?
Yeah.
This is when you're representing debtors.
So how do investors or lenders, protect themselves from bankruptcy when they're structuring a sale or a loan? Or is there anything in particular that they can do to protect themselves from bankruptcy?
It's hard to really protect yourself from bankruptcy because bankruptcy is a right. I think, when you're lending money, I think having a significant equity cushion. I'll tell you why, because I'm seeing a lot of these cases where they've already not paid you. By the time they file the bankruptcy, they're already in default for a year or two.
Right.
And so whatever equity you've had just continues to diminish as your claim continues to grow.
Right.
And so you end up upside down and you don't know how a case is going to go or what's going to happen.
Well, and if they pay you 10 cents on the dollar, you're really hosed, right? So if they owe you several $100,000 in rent, and they're going to pay you $20,000.
If you're
You're 11 or-
a landlord, yeah.
Right.
And so we were talking about getting a letter of credit, which is not the same as getting a deposit. When you get a deposit from a tenant, that becomes part of the bankruptcy estate. So,
So I have a couple of questions. I know we've kept you here a long time. So I want to ask you a couple of things. The first is, you just touched on it. A lot of landlords don't realize that these security deposits. So they say, oh, well, the tenant's kind of weak, so we're going to get like a 6-month security deposit. That security deposit, when they go into BK, is an asset of the estate. It doesn't just, the landlord can't just say, oh, well, I've got this 6 months worth of money, I'm going to go out and spend it. So
Right.
the workaround is to do what's called a letter of credit. So the money is deposited to the bank, and the letter of credit is then used for to in effect pay for expenses the landlord may incur. You touched on something. I have two thoughts and a question. The first is that with Pacific West Mortgage Fund, we rarely loan more than 65% LTV, because for just the reason that you discussed. It takes, if somebody really wants to go through the process in bankruptcy, so they file and then they refile and all the tricks. If you get much more over 65%, you're just going to lose money on these. Really, there's just no way to avoid it. So a lot of institutions, insurance companies, major banks, what they'll do is use what's called a single purpose entity when they make a loan. So they don't allow multiple owners in the LLC to prevent these filings where, owner 1 files and then owner 2 files and then owner 3 files and then owner 1 files again. So have you experienced that, or what does that work?
Well, their single purpose, one of the reasons is because there are no creditors of that entity. And therefore you can't do a Chapter 11 to reorganize that debt. So there's strategy there.
I see.
With serial filers on an individual basis, that doesn't matter, because then what I see a lot of is debtors, even though they're unauthorized transfers, but they'll do a 5% interest to, Mr. Smith, have Mr. Smith file, have that be in bankruptcy for a month or so, and then do another one. And so there are these serial filings in that regard.
Now,
But
judges
these are
don't
different.
really put up with that, though, do they? Too much, right? I mean, they'll let you do that maybe once or twice, but after that, they're going to, at least that's been my experience when that happened to me.
Right. And so what a lender should do, well, first of all, you should immediately get counsel, bankruptcy counsel. And what you can do is, it's called in rem relief from stay. So the first time you just get relief from stay in order to continue foreclosing, and then they're going to do this again and again. So after about the second time, in the third filing, you can get in rem relief, which means that the relief from stay now applies to the actual property, not the debtor. And so they can't keep doing it, and sometimes you have to record that order with the county, and then it's effective, and so that will stop it. But it will take time and some money to get there.
Yeah,
so.
I've experienced, I had a very nasty bankruptcy proceeding that took, 18 or 20 months to get through. We had filed an eviction and they filed bankruptcy, and then all these games, of repeated filings and all this stuff. And we finally were prevailed, but it was interesting because what broke the logjam was the judge just got tired of the games these guys were playing. They weren't filling out the forms. There's a bunch of schedules that they have to
Yes.
fill out, and they just would blow those off. They wouldn't come to the hearings and all this other thing. So they can stop you for a little while, but then they really have to start getting engaged and be a real person and do the things they're supposed to do to have the bankruptcy protection.
Right, and that's what I was talking about. After filing, within 14 days, you have to file your schedules of assets and liabilities and a statement of financial affairs showing everything, all your contracts. You can get an extension from the court, but you have to file a motion and request it.
Right, and that's what we were running into as well.
Yeah.
Are you able to, let's say that a loan, they file bankruptcy and you have this loan, a judge gets assigned and the judge isn't favorable to lenders. Are you able to reassign it and get a different judge?
No. You are not.
Love my dog.
You are not. Some judges are definitely more creditor friendly
Yeah.
and some are less. And then when the same debtor files over and over, it goes back to the same judge.
Oh, really? Okay.
Interesting. So you have your friends in the court, and you have your people that you dread having to work with, or?
I would just say that there are. Well, I have some friends who are judges.
Well,
but
what I mean is
otherwise
friendly
that
judges is
you
what I
know
meant.
that sometimes, you know that you're sort of in for it with certain judges for a longer haul than others.
So, in wrapping this up, Marina, I just want to make sure our listeners understand that the key thing with this bankruptcy is once it's filed, you have to really be careful about what you're doing. You don't want to be moving forward with any action you've got against these creditors until you've worked something out within the court system. Otherwise, you're really in trouble.
Yes, for sure. You should hire counsel for many reasons, because bankruptcy is its own world and you really can't navigate it, but you also need to protect your own rights. It depends, a Chapter 13 debtor can just submit a plan that doesn't pay you sufficiently, doesn't pay the interest rate, whatever the things are. You also have to file a proof of claim, and that, because in the schedules, the debtor is supposed to, when they file them, put down what every creditor is owed or what they believe is owed. And that is often not what you're actually owed. So you have to file a proof of claim to establish your claim in the case. And also, one of the things that I've come up on a few times now is that creditors will extend, so you can continue when you're in bankruptcy, and if you've already got the notice of default, and then it's the day before the sale, which often happens. You have a year from the notice of sale to continue out the sale date, and you can continue that out while the bankruptcy is pending.
Oh, interesting.
And so it's really important to keep those deadlines tight and to have your trustee in touch with your lawyer, because if you continue it out for 2 weeks and the case gets dismissed 13 days before the sale, then they've got all sorts of time to do a lot of things. And I've seen that cost thousands of extra dollars.
Yeah, that's
because
excellent.
of that.
Do you feel that as a lender, it's better to stay away from somebody who's in bankruptcy currently, and if because of the potential landmines, or is that something that you feel is reasonable and from a lender standpoint doable?
Well, I think it really just depends on the facts, and it just because if it's a company in bankruptcy. Not necessarily. You have to look at the finances. Arguably, supposedly, a company, if it's going to reorganize and come out, is healthier than when it went in.
So is it better to have it discharged first and tell them come back when it's discharged and then we'll talk?
Well, it depends on what kind of bankruptcy you're talking about and who the debtor is. It's just hard to
That's
say
that's probably
but,
a case specific.
Right, it depends. But in a chapter 11, what a lot of more recently in the last 10 years, I would say what happens is they have a pre-pack plan, so they file after they already have negotiated a plan with their creditors. Because Chapter 11 is very expensive, because the debtor's estate has to pay for all the lawyers, and the unsecured creditors committee is appointed, and then they have their own lawyers. Everyone's got their own financial advisors. It's very expensive, and if it goes on for years, it's millions of dollars.
We've read about that.
So
that's for sure.
you go in, and what often people do is negotiate that, and they do a sale right away of the assets under Section 363 of the Bankruptcy Code. So you might hear of a 363 sale. The point of that is that you get clean title, all liens are wiped out. It's just kind of a cleansing through the bankruptcy, and that's why those cases are done that way as well.
So I think the long and short of this, Marina, is that, and we could talk for hours on this subject. That's
I
for
can.
sure. So, listeners, Marina Feynman, they're down in Irvine.
Yes.
And Marina, we've worked with Marina a number of times. She's great. She's really helped us. We just recently went through a situation where a tenant filed bankruptcy and renegotiated the lease, and she was extremely helpful in getting that resolved for us. Again, thank you very much. If you find yourself in this situation, please reach out to Marina or someone like her. for assistance in this. Bill, thanks for the great questions. Patrick, thanks for the great questions. And Marina, we hope to have you back and with more.
Yes, happy to come anytime.
More time and more fun topics of bankruptcy.
Thank you for having me.
All right, thank you.
Bye-bye.